Republic Act 8353, an act expanding the definition of the crime of rape, reclassifying the same as a crime against persons, amending for the Purpose Act number 3815 as amended, otherwise known as the Revised Penal Code, and for other purposes. Section 1, short title. This act shall be known as the Anti-Rape Law of 1997. Section 2, rape as a crime against persons. The crime of rape shall hereafter be classified as a crime against persons under Title 8 of Act Number 3815 as amended, otherwise known as the Revised Penal Code. Accordingly, there shall be incorporated into Title 8 of the same code a new chapter to be known as Chapter 3 on rape, to read as follows. Chapter 3, Rape. Article 266-A, Rape, when and how committed. Rape is committed, 1. By a man who shall have carnal knowledge of a woman under any of the following circumstances. A. Through force, threat, or intimidation. B. When the offended party is deprived of reason or otherwise unconscious. C. By means of fraudulent machination or grave abuse of authority. And D. When the offended party is under 12 years of age or is demented, even though none of the circumstances mentioned above be present. 2. By any person who under any of the circumstances mentioned in paragraph 1 hereof shall commit an act of sexual assault by inserting his penis into another person's mouth or anal orifice or any instrument or object into the genital or anal orifice of another person. Article 266-B, Penalties. Rape under paragraph 1 of the next preceding article shall be punished by reclusion perpetua. Whenever the rape is committed with the use of a deadly weapon or by 2 or more persons, the penalty shall be reclusion perpetua to death. When by reason or on the occasion of the rape the victim has become insane, the penalty shall be reclusion perpetua to death. When the rape is attempted and the homicide is committed by reason or on the occasion thereof, the penalty shall be reclusion perpetua to death. When by reason or on the occasion of the rape, homicide is committed, the penalty shall be death. The death penalty shall also be imposed if the crime of rape is committed with any of the following aggravating qualifying circumstances. 1. When the victim is under 18 years of age and the offender is a parent, ascendant, step-parent, guardian, relative by consanguinity, or affinity within the third civil degree, or the common law spouse of the parent of the victim. 2. When the victim is under the custody of the police or military authorities or any law enforcement or penal institution. 3. When the rape is committed in full view of the spouse, parent, any of the children, or other relatives within the third civil degree of consanguinity. 4. When the victim is a religious engaged in legitimate religious vocation or calling, and is personally known to be such by the offender before or at the time of the commission of the crime. 5. When the victim is a child below 7 years old. 6. When the offender knows that he is afflicted with the human immunodeficiency virus, HIV, acquired immune deficiency syndrome, AIDS, or any other sexually transmissible disease, and the virus or disease is transmitted to the victim. 7. When committed by any member of the armed forces of the Philippines or paramilitary units thereof, or the Philippine National Police or any law enforcement agency or penal institution, when the offender took advantage of his position to facilitate the commission of the crime. 8. When by reason or on the occasion of the rape, the victim has suffered permanent physical mutilation or disability. 9. When the offender knew of the pregnancy of the offended party at the time of the commission of the crime. And 10. When the offender knew of the mental disability, emotional disorder, and or physical handicap of the offended party at the time of the commission of the crime. Rape under paragraph 2 of the next preceding article shall be punished by prison mayor. Whenever the rape is committed with the use of a deadly weapon or by 2 or more persons, the penalty shall be prison mayor to reclusion temporal. When by reason or on the occasion of the rape, homicide is committed, the penalty shall be reclusion perpetua. Reclusion temporal shall also be imposed if the rape is committed with any of the 10 aggravating qualifying circumstances mentioned in this article. Article 266-C, effect of pardon. The subsequent valid marriage between the offender and the offended party shall extinguish the criminal action or the penalty imposed. In case it is the legal husband who is the offender, the subsequent forgiveness by the wife as the offended party shall extinguish the criminal action or the penalty, provided that the crime shall not be extinguished or the penalty shall not be abated if the marriage is void ab initio. Article 266-D. Presumptions. Any physical overt act manifesting resistance against the act of rape in any degree from the offended party, or where the offended party is so situated as to render her or him incapable of giving valid consent, may be accepted as evidence in the prosecution of the acts punished under Article 266-A. Section 3. Separability Clause. If any part, section, or provision of this act is declared invalid or unconstitutional, the other parts thereof, not effective thereby, shall remain valid. Section 4. Repealing Clause. Article 335 of Act No. 3815 as amended, and all laws, acts, presidential decrees, executive orders, administrative orders, rules, and regulations inconsistent with or contrary to the provisions of this act are deemed amended, modified, or repealed accordingly. Section 5. Effectivity. This act shall take effect 15 days after completion of its publication in 2 newspapers of general circulation. Approved, signed, Jose de Venecia Jr., Speaker of the House of Representatives. Ernesto M. Maceda, signed, President of the Senate. This act, which is a consolidation of Senate Bill No. 950 and House Bill No. 6265, was finally passed by the Senate and the House of Representatives on June 5, 1997 and September 3, 1997, respectively. Signed, Roberto P. Nazareno, Secretary General, House of Representatives. Signed, Lorenzo E. Lainez Jr., Secretary of the Senate. Approved September 30, 1997. Signed, Fidel V. Ramos, President of the Philippines. Republic Act 8353, an act expanding the definition of the crime of rape and reclassifying the same as crime against persons. The Anti-Rape Law of 1997 redefines rape as a crime against persons. Rape violates a person's well-being and not just one's virginity or purity. The law considers that any person, whether a prostituted person, non-virgin, or one who has an active sexual life, may be victimized by rape, a public offense. By declaring that rape is a crime against persons, the law no longer considers it as a private crime. Anyone who has knowledge of the crime may file a case on the victim's behalf. The prosecution continues even if the victim drops the case or pardons the offender. What constitutes rape? Rape is committed by a man who shall have sexual intercourse with a woman under any of the following circumstances: through force, threat, or intimidation, when the victim is deprived of reason or is unconscious, through fraudulent machination or grave abuse of authority, and when the victim is under 12 years of age or is demented, even if none of the above circumstances are present, by any person who, under any of the above circumstances, commits an act of sexual assault by inserting his penis into another person's mouth or anal orifice or any instrument or object into the genital or oral orifice of another person. Who can be raped? Anyone can be a rape victim, but the incidence of rape is more rampant in women and girls. Who can commit rape? Any man or woman may be held liable for rape. It is possible that a man may rape his own wife, an act deemed as marital rape. The penalty for rape in general may apply on the offender who commits marital rape. How is the crime punished? The penalty varies depending on the act itself and the circumstances surrounding it. Reclusion perpetua, imprisonment from 20 to 40 years, is imposed on the offender if rape is committed through sexual intercourse. Prisión mayor, imprisonment from 6 to 12 years, is imposed on the offender if rape was committed through oral or anal sex or through the use of any object or instrument that was inserted into the mouth or anal orifice of the woman or a man. This may also be elevated to reclusion temporal, imprisonment from 12 to 20 years, or reclusion perpetua, depending on the circumstances surrounding the crime. What to do if someone is raped? 1. Advise the victim to seek the help of a counselor or a therapist who is an expert in handling cases of sexual abuse. 2. Assist her in securing a safe and temporal shelter. If she needs to move to another place for security reasons, she can be referred to a crisis center or any government agency that offers temporary shelter. 3. Make sure that the evidence is safe and intact. This would help should the victim decides to file a case. 4. Secure a medical legal certificate from a medical legal officer. Absence of bodily injuries does not mean that rape did not occur or that the case may not be pursued anymore. 5. Support the victim along the way when she decides to file a case. 6. Ensure that she is prepared in all aspects. Make her understand the overall picture of the case. Inform her that it is possible that doctors, police, lawyers, and judges would not be sensitive to her situation and experience. 7. Help the victim choose the lawyer who understands her most. 8. Coordinate with people who can assist or support her all throughout. Legal harassment, everything you need to know. Harassment can take various forms including physical, sexual, verbal, or cyber harassment by emails or social media. This type of activity is frequently planned and repeated. Harassment can result in both civil and criminal consequences for the perpetrator. Harassment in the legal sense relates to actions that appear to be distressing, upsetting, or threatening. They arise from discriminatory motives and have the consequence of nullifying or restricting a person's ability to exercise their rights. When these behaviors occur regularly, they may be considered bullying in common parlance. The consistency of repetition and the upsetting, worrisome, or menacing quality may be apart from a simple insult or admonition. Harassment law and legal definition. State laws define harassment as behavior patterns that bother, threaten, intimidate, alarm, or place people in fear of their safety. Harassment is unwelcome, uninvited behavior that degrades, threatens, or offends the victim, creating a hostile environment. Harassing behavior can include but is not limited to epithets, derogatory comments, or slurs and lewd propositions. It also includes assault, physical interference with normal work or movement, impeding or blocking movement, offensive touching, and visual insults like derogatory posters or cartoons. What constitutes harassment unlawful? Harassment is illegal discrimination if it occurs as a result of or in connection with one of the following factors: age, gender assignment, ethnicity, faith, religion or belief, sexual orientation. These are referred to as protected qualities in the Equality Act. Harassment connected to a protected characteristic is when someone is harassed because of one of these characteristics. Reasons or aims behind the harassments. Harassment is defined as behavior that is intended to or has the impact of either violating your dignity or creating an intimidating, hostile, humiliating, degrading, or offensive environment, indicating that harassment occurs even if the harasser did not intend to offend or frighten you. As long as the harassment produces one of the outcomes listed above, if you go to court, the judge may have to assess whether or not the behavior is harassment. They'll consider how the behavior made you feel and whether the judge justified your feelings. Type of legal harassment. 1. Criminal harassment. State laws define criminal harassment. Though each state defines criminal harassment differently, in most circumstances, you must demonstrate the presence of the following factors to pursue a criminal harassment claim. The defendant acted with malice. The actions were monotonous. The activities posed a credible threat to the victim or their family's safety. Harassment accusations can range from a minor infraction to a serious felony. Before considering what the defendant should be charged with, courts weigh various considerations, including past crimes and if the defendant violated a restraining order. The defendant's target of a protected group is also taken into account by the courts. When someone targets victims based on their national origin, ethnicity, religion, gender, sexual orientation, age, or disability, this is known as profiling. If you're facing a harassment charge, it's a good idea to consult with a criminal defense lawyer to help you through the legal system and preserve your rights. 2. Civil harassment. Cases of civil harassment are not prosecuted as criminal offenses. In civil harassment cases, you can file a civil lawsuit alleging discrimination due to the harassment. In the following situations, civil harassment lawsuits are very common. 3. Harassment in the workplace. Discrimination in the workplace is protected under Title 7 of the Civil Rights Act of 1964. Discrimination based on race, gender, national origin, and religion are all examples of this. State and local governments have also passed legislation to protect employees from discrimination in the workplace. Even the most seasoned HR professionals are prone to overlooking signs of provocation in the workplace. It's nearly impossible to keep track of what each of your representatives is doing regarding harassment. Representatives have their unique ideas about how to conduct themselves professionally in the workplace. One employee may think reviled praises are acceptable in regular conversations with coworkers, while other believes they are never acceptable and finds them particularly unfriendly. 4. Written or verbal harassment. The most obvious workplace provocation, and the one you run into regularly, is verbal or written. Composed harassment is when someone sends a message with offensive jokes or images concerning race or religion. Composed harassment is when someone asks for these or sexual favors more than once, either in person or by text. Obtaining information regarding a family's medical history or a hereditary condition is a kind of verbal or written harassment. 5. Physical harassment. Physical harassment is defined as the use of obnoxious hand signals or other actions to convey derogatory statements. Physical harassment includes unwanted touching of a guy or his clothing. Physical provocation is defined as following a man as often as possible or standing overly close to him on purpose. 6. Visual harassment. Visual is perhaps the most difficult to identify because it is the most subjective and requires you to put yourself in the shoes of a reasonable person. Visual harassment is when someone wears clothing that has a hostile or unpleasant tone. Visual harassment is defined as the display of sexually explicit blurbs or photographs. How to stop harassments. Keep calm and don't feel compelled to rush to your boss every time something happens. If the tormenting persists despite everything, you have the option of taking your case to the next level, whether it's to a higher level administration employee or a legal counselor. Most work lawyers provide a free consultation and will provide you with their expert legal advice. Filing a lawsuit. You must first file an administrative charge with a state agency before filing a discrimination or harassment case under federal law. There is a legal requirement. They will dismiss your lawsuit if you file a lawsuit before filing a charge, technically known as exhausting your administrative remedies. Before bringing a discrimination or harassment lawsuit based on state law, several states require employees to file an administrative complaint with the state's Fair Employment Practices Agency. Unless the agency decides to bring a lawsuit on your behalf, which is extremely unlikely, it will finally finish processing your claim and provide you with a notice of right to sue. You have the option of filing a lawsuit once you receive the letter. After receiving your right to sue letter, there are short deadlines for submitting an administrative charge and launching a lawsuit. If a lawyer doesn't already represent you, you should get legal counsel as soon as possible. A lawyer can evaluate the merits of your claims, ensure that you do not miss any deadlines, design your administrative charge, and assist you in negotiating with your employer. After receiving your right to sue letter from a state or federal administrative agency, you may bring a lawsuit. For questions regarding filing a lawsuit, you require the assistance of a lawyer. As a result, you should consult an attorney when subjected to illegal workplace harassment or discrimination. Republic Act 7877, the Anti-Sexual Harassment Act of 1995. What is sexual harassment? Under RA 7877, work, education, or training related sexual harassment is committed by an employer, employee, manager, supervisor, agent of the employer, teacher, instructor, professor, coach, trainer, or any person who, having authority, influence, or moral ascendancy over another in a work or training or education environment demands, requests, or otherwise requires any sexual favor from the other, regardless of whether the demand, request, or requirement for submission is accepted or not by the object of said act. How is work-related sexual harassment committed? Work-related sexual harassment is committed when 1. The sexual favor is made as a condition in the hiring or in the employment, re-employment, or continued employment of said individual, or in granting said individual favorable compensation, terms, conditions, promotions, or privileges, or refusal to grant the sexual favor results in limiting, segregating, or classifying the employee which in any way would discriminate, deprive, or diminish employment opportunities or otherwise adversely affect said employee. 2. The above acts would impair the employee's rights or privileges under existing labor laws. Or 3. The above acts would result in an intimidating, hostile, or offensive environment for the employee. How is education or training related sexual harassment committed? Education or training related sexual harassment is committed 1. Against one who is under the care, custody, or supervision of the offender. 2. Against one whose education, training, apprenticeship, or tutorship is entrusted to the offender. 3. When the sexual favor is made a condition to the giving of a passing grade or granting of honors and scholarships or the payment of a stipend, allowance, or other benefits, privileges, or considerations. Or 4. When the sexual advances result in an intimidating, hostile, or offensive environment for the student, trainee, or apprentice. A person who directs or induces another person to commit any act of sexual harassment or who cooperates to commit the act, without which the said act would not have been committed, will also be held liable under the law. What is the duty of the employer of head of office in a work or education training environment? The employer or head of office is required by the law to prevent the occurrence of sexual harassment acts and to provide the procedures for the resolution, settlement, or prosecution of sexual harassment. Towards this end, the employer or head of office shall 1. Promulgate appropriate rules and regulations in consultation with and jointly approved by the employees or student or trainees through their duly designated representatives. Said rules and regulations shall prescribe the procedures for the investigation of sexual harassment cases and the administrative sanctions thereof. The said rules and regulations should include guidelines on proper decorum in the workplace and educational or training institutions. Administrative sanctions shall not be a bar to prosecution in the proper courts for unlawful acts of sexual harassment. 2. Create a committee on decorum and investigation CODI of cases on sexual harassment. The committee shall conduct meetings, or as the case may be, with officers and employees, teachers, instructors, professors, coaches, trainers, and students or trainees to increase understanding and prevent incidents of sexual harassment. It shall also conduct the investigation of alleged cases constituting sexual harassment. In the case of work-related environment, the committee shall be composed of at least one representative, each from the management, the union of it, if any, the employees from the supervisory rank, and from the rank and file employees. In the case of the educational or training institution, the committee shall be composed of at least one representative from the administration, the trainers, teachers, instructors, professors, or coaches, and students and trainees as the case may be. The employer or head of office, educational or training institution shall disseminate or post a copy of RA 7877 for the information of all concerned. What if the employer or head of office did not undertake any action despite his or her knowledge of the sexual harassment acts? The employer or head of office, educational or training institution will be held liable for the damages arising from acts of sexual harassment if they are informed by the offended party of the occurrence of such acts yet no action has been undertaken. Can an offended party seek redress by taking an independent action? Yes, the offended party may take independent action for damages incurred in the act of sexual harassment. She or he may also avail of relief. What are the penalties for offenders? Where do we go for help? For government sector employees, Civil Service Commission, Constitution Hills, Batasang Pambansa Complex, Diliman, Quezon City, Public Assistance Desk, 028931-7913/8931-8187. Para sa Taong Bayan Hotline, 028951-2575/8932-0111. For private sector employees, Department of Labor and Employment, Bureau of Working Conditions, Intramuros, Manila Hotline, 1349/021349 for calls outside Metro Manila. Philippine National Police Women and Children Protection Center, Camp Crame, Quezon City, telephone number 410-3213/532-6690. Aling Police Text Hotline 0919-777-7377. National Bureau of Investigation Anti-Violence Against Women and Children, Desk, Taft Avenue, Manila, telephone numbers 5238-231238/5256028. DOJ Public Attorney's Office, DOJ-PAO, telephone numbers 929-9010/929-9436237, Lock 106-107.